All right, day 5 of the Bondi detention crisis, and the unthinkable just happened. The President of the United States tried to use the most powerful tool in his arsenal, the presidential pardon, to pull his own Attorney General out of a federal detention cell. The Chief Justice of the United States looked him in the eye and said no. 5 days, one ruling, 236 years of assumption, shattered. Stay with me, because what just happened goes so much deeper than one woman in one cell. The pardon that wasn't? Let's set the scene before we go deeper. Pam Bondi, Attorney General of the United States, is sitting in federal detention. Not accused of a crime in the traditional sense, held in contempt. Held because a federal judge, Judge Caldwell, issued a court order. Bondi defied it. And the judiciary did something the executive branch genuinely did not believe was coming. It enforced itself. Day 1. Judge Caldwell holds Bondi in contempt. Detains her pending compliance. Not a fine, not a warning, detention. Day 2. Trump erupts. Demands her release. Warns the judiciary of consequences. The judiciary doesn't blink. Day 3. Bondi's legal team races to the D.C. Circuit. 3 judges. Emergency appeal. They lose. 3-0. No dissent. Day 4. Trump announces the pardon. Declares contempt is a federal offense. Says presidential pardon authority is absolute. Has been for 236 years. Says he's ending this. Day 5. Chief Justice John Roberts issues an emergency ruling. Presidential pardon power does not extend to judicial contempt. The court's inherent authority to enforce its own orders exists in a separate constitutional category. Pardon denied. Bondi stays. That's the sequence. Now let me show you why nothing about American government will ever look exactly the same again. What Roberts actually did. Here's what the coverage keeps getting wrong. Everyone's framing this as Trump loses. Roberts wins. A political scorecard. A headline. That's not what happened. What Roberts did, quietly, methodically, with a written opinion that constitutional scholars are going to be reading for the next 100 years, is draw a boundary line that no Chief Justice has ever had to draw before, because no president has ever forced one to. He didn't just block a pardon. He established that the pardon power, that broad, sweeping, almost mythological authority granted in Article 2 of the Constitution, has a wall, a structural wall, built into the architecture of the Constitution itself, hiding in plain sight for 2.5 centuries. Waiting for a moment exactly like this one. Roberts' argument is precise, and it's devastating in its simplicity. Presidential pardon authority covers federal offenses, criminal offenses, matters of law that originate within the executive branch's jurisdiction. That's the pardon power. That's always been the pardon power. Judicial contempt is different, fundamentally different. Judicial contempt isn't a federal crime handed down by statute. It's the court's inherent authority, built into Article 3 by the founders themselves, to enforce its own orders, to make itself real, to ensure that when a federal judge issues an order, that order means something. If the president can pardon away contempt, then a president can effectively nullify any court order anytime by simply issuing a pardon to whoever defied it. The judiciary becomes decoration. Its orders become suggestions. Its injunctions become inconveniences that a willing president can dissolve with the stroke of a pen. Roberts didn't say Trump is wrong politically. He said the Constitution doesn't allow what Trump tried to do. The structure won't permit it. That's a different thing entirely. 236 years. Let that number breathe for a second. 236 years. George Washington, John Adams, Thomas Jefferson, Abraham Lincoln, Franklin Roosevelt, every president who ever tested the limits of executive power, and some of them tested hard, none of them ever ran into this wall. Not because the wall wasn't there, because none of them ever tried to pardon their way out of judicial contempt of this nature. The pardon power has been called absolute so many times by so many legal scholars, by so many attorneys general and White House counsels across administrations of both parties, that it had essentially calcified into accepted truth. You couldn't challenge it. You could barely even debate it seriously in a law school classroom without someone citing the breadth of Article 2 and shutting the conversation down. Until Tuesday. Now the debate is over. Not because scholars argued their way to a consensus, because a sitting Chief Justice in an emergency written opinion drew the line himself. And the line is permanent unless 2/3 of Congress and 3/4 of states amend the Constitution to erase it. That's not happening. View how this actually hits, and it isn't who you think. The coverage keeps circling back to Bondi, to Trump, to this specific confrontation. That's the wrong camera angle. Let me show you the real frame. Group 1. Every future president. Every single one. Here's the thing about constitutional precedent. It doesn't care what party you belong to. It doesn't care who you voted for. It doesn't have a registration card or an ideology. Roberts just limited presidential power. Full stop. The next Democratic president who wants to protect a cabinet member from contempt can't. The next Republican president who instructs an agency head to resist an injunction and assumes they have a pardon as a safety net doesn't. This ruling applies forward, permanently, universally. Every political operative in every future administration is going to read Roberts' opinion and feel the same cold realization. The escape hatch they always assumed was bolted shut is now welded shut from both sides. Think about what that changes strategically. Presidents, since the founding, have operated with a quiet background assumption, push the judiciary hard, resist orders when politically valuable. Worst case, pardon anyone who gets caught in the fallout. Move on. That calculation is gone. Erased, not weakened, erased. Group 2, 4,000 Trump administration officials. Senate confirmed, senior appointed, approximately 4,000 of them. Every single one of them came into this administration with the same background assumption that every senior official in every modern administration has carried. The president can protect you. If you follow orders, even controversial orders, the pardon power exists as a last resort safety net. That safety net just disappeared. Think about what that means in practical terms. An ICE director implementing a deportation policy that a federal court has enjoined. Before Roberts, the director proceeds. Worst case, contempt charge, presidential pardon, crisis resolved. After Roberts, the director proceeds. Worst case, contempt charge, federal detention, no pardon, no rescue, career ended, freedom compromised. The personal risk calculation for every senior official in every controversial policy area just changed overnight. And those officials are smart. They have lawyers. They read. They're going to start complying with injunctions they previously would have resisted, not because they believe in the policy anymore or less, because the math changed. Compliance is now the rational choice in a way it simply wasn't before Tuesday. Group 3. 870 federal judges. Here's the group nobody is celebrating loudly enough. Every Article 3 federal judge in the country just received something they have never formally possessed in 236 years of American constitutional history. Guaranteed enforcement authority, independent of the executive branch, immune to the pardon power. Think about what federal judges have been working with up to this point. They issue orders. They issue injunctions. They hold officials in contempt. And in the back of every courtroom, hovering over every ruling, was this quiet vulnerability. If the president decides to protect someone from contempt, the pardon exists. The court can rule. The court can hold in contempt. The court cannot ultimately prevent the executive from escaping consequences. Roberts just changed that. A district court judge in Texas or anywhere who issues an injunction against a federal policy now operates from a position of genuine power. The administration knows the contempt detention is real. The administration knows the pardon can't reach it. The judge's order carries weight. It has never technically carried before. 870 federal judges woke up Tuesday morning with less institutional power than they went to sleep with Monday night. They woke up Wednesday morning with more. That shift is enormous, and it is permanent. The 3 changes nobody is fully processing. Let me slow down and make this concrete, because the implications are moving faster than the coverage. Change 1. The pardon has a ceiling. Before Tuesday, the academic and legal consensus, not unanimous but dominant, was that Article 2 pardon authority was essentially limitless for federal offenses. Some scholars even argued it extended to the president themselves. The ceiling, if it existed, was purely political. Public pressure, congressional response, electoral consequences. After Tuesday, the ceiling is structural. Judicial contempt sits above the pardon power. The court's inherent enforcement authority exists in a constitutional tier that Article 2 cannot reach. That structural ceiling will be cited in courtrooms for generations. Every future pardon dispute that touches on contempt will start with Roberts' Tuesday ruling. Every future attorney arguing that a pardon covers contempt will lose that argument before they finish making it. The precedent is set, the ceiling is fixed. Change 2. The balance of power just moved. For the entire modern era of executive-judicial conflict, there was an understood dynamic. Judges issue orders. Executives sometimes resist. The judiciary has legitimacy and legal authority. The executive has actual physical enforcement power. The marshals, the agents, the institutions that carry out rulings in the real world. And the executive has the pardon as the ultimate backstop. Courts knew this. They operated around it. They were careful not to push confrontations too far because the structural leverage ultimately favored the executive. Tuesday changed that leverage. Judicial contempt, immune to pardon, directly enforceable through detention, is now the judiciary's independent enforcement mechanism. It doesn't need the executive to carry it out. It doesn't need the pardon power to be absent. It operates on its own authority. The judiciary gained real enforcement teeth Tuesday. The executive lost a foundational assumption. The scales tipped, not violently, not completely, but measurably, permanently, and in a direction that 236 years of precedent said wasn't possible. Change 3. The contempt exception exists now. This is the change that reaches furthest into territory most people haven't started mapping yet. Before Tuesday, there was no formal contempt exception to the pardon power. No case had forced the question. No Supreme Court ruling had addressed it directly. Legal scholars debated it as a theoretical matter. Courts assumed the question. After Tuesday, the contempt exception exists. It is real. It is Supreme Court precedent. And it applies everywhere judicial contempt is a potential consequence. Congressional subpoenas, enforced through courts, now carry real teeth. Executive officials who defy subpoenas, who get held in contempt by a federal court at Congress's request, now face detention that a presidential pardon cannot reach. Agency officials defying injunctions. White House staff ignoring document preservation orders. Senior officials resisting discovery in civil litigation brought against the government. In every one of those contexts, contempt detention is now a consequence that the president cannot pardon away. Roberts didn't just rule on Bondi. He restructured the relationship between all three branches of the federal government, simultaneously with a single emergency opinion. The ripple effects nobody is connecting. Waves don't stop at the shoreline you're watching. State courts and governors? Roberts' ruling is federal constitutional precedent, but it carries persuasive authority that state courts across the country are already watching. If federal judicial contempt sits outside presidential pardon authority at the federal level, state court judges have new legal architecture to argue that state judicial contempt sits outside gubernatorial pardon authority. Governors in states with aggressive court executive friction are about to get a constitutional headache they weren't expecting from a case they weren't directly involved in. Congressional oversight. Congress has spent decades watching its subpoena power weaken in real time. Executive privilege claims, slow-walked productions, outright defiance. The practical consequence was always this. Congress could hold officials in contempt, but if the president was willing to issue a pardon, the subpoena's enforcement mechanism was ultimately toothless. Tuesday changed the calculation entirely. Congress can now refer contempt to federal courts, or pursue court-enforced contempt directly with the knowledge that presidential pardon cannot reach the consequence. An official who defies a congressional subpoena, whose contempt is court-enforced, sits in detention with no pardon escape. Congressional oversight just gained structural leverage it hasn't possessed in modern political history. Watch the Judiciary Committee. Watch the subpoenas already in motion. They were drafted before Tuesday. They're going to be served with entirely different force after it. International implications. This one is being missed almost entirely by domestic coverage, and it matters. Allied governments in Europe, and specifically the parliamentary democracies that have been watching American institutional resilience with mounting anxiety since 2017, just watched the American judiciary enforce its orders against a sitting administration, independently, without executive compliance. If the executive branch respects it, If enough officials within the executive branch place their loyalty to constitutional order above their loyalty to any individual president, if Trump escalates, if he orders release, if the marshals face a direct conflict between Roberts' detention order and a presidential directive to comply, nobody knows what happens. There is no precedent, there is no manual, there is no practice drill for that scenario. We are one decision away from finding out. 3 scenarios, 1 country. Which path? This doesn't have a clear ending yet. Let me show you the 3 roads this could take. Scenario A, institutional resolution. Trump accepts Roberts' ruling. His legal team advises him that the battle isn't worth the cost. Bondi, who has been sitting in detention for 5 days and whose lawyers are watching this spiral beyond anything they anticipated, complies with the original court order. Documents are produced. Contempt is purged. Bondi is released. Roberts' ruling becomes accepted precedent without being tested at its most dangerous edge. The system holds, everyone moves on, the constitutional limit on pardon power is established and uncontested. Probability, 35%. It's possible. Trump has accepted judicial losses before, publicly minimized them, and moved to the next fight. This could be that. Who wins? The judiciary, the rule of law, Bondi personally. Who loses? Trump loses the pardon battle and sets a precedent that limits his own future options. Future presidents lose a tool. Scenario B, the prolonged standoff. Trump doesn't accept the ruling, but doesn't directly defy it. He appeals, he litigates, he makes political noise, he calls Roberts partisan, he fundraises on judicial overreach. Bondi remains detained for weeks, possibly months, while the legal process grinds through every available procedural avenue. The constitutional questions remain technically unresolved at their sharpest edge because Trump never forces the ultimate confrontation. Roberts' ruling stands but isn't tested to its physical limits. Probability 45%. This is the most likely path because it lets Trump perform resistance without triggering the scenario where marshals face conflicting orders. It maintains the political narrative without the genuine risk of institutional collapse. Who wins? Lawyers, media, Roberts? Whose ruling stands without being truly tested? Who loses? Bondi remains detained. DOJ remains in chaos. The public gets no resolution. Scenario C, constitutional crisis. Trump orders U.S. Marshals to release Bondi directly. Defies Roberts' ruling explicitly and physically, forces every official in the executive branch to choose between presidential directive and judicial order in real time. If the marshals comply with Trump, judiciary blinks, the court's authority is proven hollow, executive power expands beyond any previous limit in American history. The institution Roberts has spent his career protecting suffers a wound it may not recover from. If the marshals refuse Trump, we are in territory so unprecedented that no one can accurately model the consequences. Probability, 20%. It's the highest risk scenario for everyone involved, including Trump. But 20% is not zero. And if Trump's political base demands visible action, if he calculates that backing down costs him more than confronting Roberts, the number moves. Who wins if it succeeds? Executive power for a generation? Who loses? Everyone else. Every institution, every norm, every structure the founders built to prevent any single branch from consuming the others. The variable that determines everything and that nobody is watching closely enough. What do the U.S. Marshals do if forced to choose? What happens next and when to watch? Short term. The next 7 days. Wednesday's Senate Judiciary Emergency hearing is the first institutional response beyond the courts. Watch which Republicans show up. Watch whether any of them defend Roberts' ruling on its constitutional merits rather than attacking it on political grounds. That tells you where the Republican Party's institutional instincts actually are. Friday, the Supreme Court is expected to rule on any Trump appeal of Roberts' emergency order. That ruling tells you whether Roberts is speaking for himself or for the court. 5 justices affirming him means scenario C becomes significantly less likely. A fractured court means everything becomes less predictable. Watch Trump's language, not the tweets, the language. If he's